we'll let you know when we're live streaming. The case is now being recorded.
Good morning. Welcome to the October 1st, 2024 sitting of the Massachusetts Appeals Court. Usual appeals court rules are in effect. Each side will have 15 minutes to make their presentation, and there is no rebuttal. Our first case on the list is docket 23P674, Commonwealth versus Thomas. We will hear first from counsel for the appellant, Attorney Liddy. Good morning.
Good morning, Your Honors. Attorney Jean Liddy on behalf of Adrian Thomas. And thank you for letting me appear by Zoom. I had a lengthy homicide trial, and I even had to file late to appear before you this way. So thank you for that. I thought about how to approach this case, which is a case of prosecutorial misconduct in Adrian Thomas's view. And it's one that tells a story of a cumulative effect that got to prosecutorial misconduct. And this case began with the opening and the closing, and that's pretty much how the story should start. In the opening itself, the prosecutor was ordered not to talk about phone calls, jail calls, and that should come out later in testimony. However, during the opening, he did bring in the telephone calls, the jail calls, and he made a lot of argument in his opening statement, and adduced argument as to things that were not going to be able to come in during trial. For instance, he told the jury to pay close attention to police testimony and that they should agree with him. He talked about the defendant's motive. He talked about the jail calls, and that the men, Estrada, who was severed from the case, was best friends with Mr. Thomas.
Let me stop you there. I have a couple of preliminary questions. My first is, did evidence of the phone calls and their content ultimately come in at trial?
Well, partially. There were 40 minutes of phone calls, and Detective or Officer Canini listened to all of them. Approximately half of them didn't come in. So there was a hearing about that, but Officer Canini testified to and characterized the entirety of them, although the jury never had the entire phone calls. So anyway, he did, back to the opening, he did say, we all have best friends. Imagine your car was taken by a best friend, and the first opportunity somebody has to talk about their best friend, they never bring it up. Think about that. So right off the bat, he's telling them to pay close attention to the police, pay close attention to what defendant knew to distance himself from, and that his best friend had committed a crime. So already the stage is set for the jury to hear the opinion of the police, the opinion of the prosecutor, and the opinion of the characterization of what happened. And that's very important because the judge had ordered him not to open with the phone calls because that was something that needed to be addressed during trial. In the closing argument, same thing. And that's why I'd like to bookend the argument with opening and closing, because I think that's really important. Because then we can talk about the cumulative effect of the officers and how it was vouching and so forth. Same thing. He reiterated the best friend opinion that he had, even though that did not come in evidence.
So certainly evidence.
Yeah, go ahead.
Go ahead, Judge Toone.
No,
please.
I mean, in both the opening statement and closing argument, prosecutors allowed to make, to sort of set what the evidence is going to say or has said, and also draw reasonable inferences from that evidence. And there was evidence from some of the jail conversations where the defendant and Mr. Estrada told each other that they loved each other, right? So
sure.
And there was a friendly tone throughout. So there certainly was evidence to support a friendly relationship. Why does using the term best friends kind of cross a line in your view?
Sure. It's not just that. It's the cumulative effect of it. And that's important because the police and the prosecutor are characterizing what the jail calls say. You see what I mean? So in other words, they're saying, yeah, I love you, you know, bro, this, bro, that. You could take that a number of ways. It could be vernacular of the way people talk. Of course, they had some sort of a friendship, but in his opening, he talks about your best friend, and his whole would you not ask your best friend, why'd you take my car? That was his theory. And you're dealing with a case where you have willful and knowing are count 1 and 2. So it's state of mind. It deals with intent. And he's setting the stage of allowing the police officers to kind of buttress his opening and closing with their characterization of conversations, of jail calls, and so forth. And again, it's not just that. He says in his closing that the words of these calls impacted what his best friend was going to do. And remember, Estrada was severed from the case. He committed a nebulous crime, some other place, some other, area that they didn't talk about what the crime was, but they kept referring to this crime as something that happened, and allowed the jury to speculate about that because of his best friend. It impacted him. And,
Well,
and also,
that was a ruling to protect the interests of the defendant here, right? Like,
sure,
it was discussed at a pretrial conference that it was a drive-by shooting, right? And the judge said, we're
right.
not going to get into that. We're not going to
No.
talk about shooting. We're just going to talk about crime. And defense counsel didn't object to that kind of way of handling the situation, right?
But see, again, it's a little more subtle than that. It's not so much that he didn't talk about the drive-by shooting. It's that in the closing, the prosecutor said that the booking call, the defendant was giving Estrada information, giving it to him. It goes to motive. He gave him information. He gave him information about his best friend. The lack of reaction, he wanted to distance himself from the crimes, that kind of thing. So he's setting up. There's a bad crime out there. He's not talking about what the crime is. He's alluding to it, and the entire theme and the weaving of his opening and closing through the testimony is a way for the jury to understand, in his view, that there was this bad crime out there, and that because it was a best friend and he didn't react, and that all of this was characterized with the police testimony, I would suggest that wanting to distance himself, and that how it impacted Estrada, it almost seems like it's a conspiracy, instead of just saying, did he willfully, knowingly lie on the motor vehicle stolen application, and did he willfully and knowingly, it's specific intent to deceive the police as far as their investigation, and that kind of goes to a lot of the arguments that I had, because state of mind and intent, and the prosecutor's personal belief and vouching and all of the things I talked about at length in my brief, it all weaves together. So if you look at, for instance, let's take some of the officers, which I think are really important. You look at Levesque. He talks about even though there was a curative instruction, he wasn't charged with the other crime. He still talks about for almost 19 pages, about how there was this other crime he was investigating, and all the officers were investigating the other crime. And for Resto, the nature of the relationship between the two men, was the prosecutor repeatedly asked about it because he wanted to get the answer that they were best friends. And finally, the judge stepped in and said, look, you're trying to get him to answer a certain way. But as we know in trial, if you ask repeated questions, it's going to weigh on the jury's mind. And alone, it's an unrung bell. And alone, that standing alone, it may not be too much, as Your Honor points out, because there was another crime. But cumulatively, and especially with the argument in the beginning at opening, and it becomes kind of like this overwhelming force that's too much to unwind for the jury. And that's where I think dealing with prosecutorial misconduct and dealing with the cumulative effect, there comes a point where there is a line that it kind of goes off a cliff, and that's what we're saying. And then, another thing was the stolen motor vehicle a misunderstanding? Did the defendant tell you that? And then, questions like, are you actively attempting to find out? Could you hear him asking questions to, Madeira, and characterizing the questions? Madeira's the responding officer, and, he's on his cell phone, and Madeira's characterizing it. Did you hear him? Isn't he actively, that kind of thing. And Kanini, I think, is exceedingly important to this analysis, because he's listening, as your honors pointed out, he's listening to the jail calls. And instead of just giving them to the jury, he's characterizing them. He's saying, the jury's not going to have all of the calls, as was pointed out here, only part of them. And there's 40 minutes of calls, and then he's allowed to testify to the ones that aren't admitted, to the ones the jury does not.
So let me ask, what exactly is the legal error there? I'm just trying to understand how you kind of conceptualize it, because he
Sure.
said, yes, you're right, not all the calls were admitted to the jury. Some of the calls were admitted in redacted form. Some calls weren't submitted to the jury at all. And Kanini listens to all the calls and says, the defendant never asked Estrada, why'd you take my car? Right. That was sort of the thrust of his testimony. But what's the evidentiary problem with that? I'm trying to understand why is that erroneous?
Sure. I think standing alone, as your honor points out, standing alone, any one of those things in isolation, may not be so much of a problem if you have other evidence. The problem with this case is you have only characterized evidence by officers. You have the booking video with Estrada. You have the jail calls with Kanini. You have the Resto and Levesque, and they're all characterizing the defendant's not asking or the defendant's relationship with Estrada. And again, you have Kanini talking about, he's characterizing it. He's talking about, he didn't ask. And no, I heard all of the calls and he didn't ask. And yes, that's his voice. And I know it's his voice because, I heard him. I heard the voice with the interview with the other officer, and and that kind of thing. So it's kind of woven in, and it is subtle, and it is an analysis which is why I wanted to start with the opening, which so often isn't argument, and usually prosecutorial misconduct facts aren't in evidence or it's vouching, but it's right out of the gate. You start with this problem, and right out of the gate, the jury is told, pay attention to the officers, and you will agree. You will agree. And, so it implies that whatever the officers are going to be saying and characterizing go to a motive and go to intent and go to state of mind. And it becomes the prosecutors vouching at the end because it's his personal belief in that theory rather than the veneer and the fact finder weighing the evidence and hearing it themselves. So to that point about the jail calls, yes, standing alone in isolation, perhaps, he could have done that. I would suggest that he shouldn't have characterized the entirety and just characterized what the jury was going to be able to listen to in the juror room instead of the full 40 minutes, because then you get into the jury thinking, wow, there must be something else going on that the prosecutor and the officers know about. And it's like a special knowledge. And I don't believe the special knowledge was addressed by my brother, but that is part of it because, again, when you're dealing with state of mind, which I don't think that also was addressed, but when you're dealing with state of mind and motive and vouching and the personal belief of the prosecutor and all of these moving parts, it's important in this case because you're dealing with intent in the two indictments, willful and knowing. And I think, having it come right out of the gate like that in such a shocking way, where the jury's told that they should agree with the police and told that there was a motive to file and that he knew they were best friends. And imagine, that he's telling the jury right out of the gate, imagine your best friend. So it's like telling the jury, this is the intent. And officers are going to tell you the intent. Oh, I'm sorry, my time expired. I'm
Thank
sorry.
you. That's okay. Let me see if there are any other questions from the panel. Justice Singh? No, Justice Toone?
Okay.
Thank you, Attorney Liddy. We appreciate your presentation. We will
Thank
now hear
you.
from the Commonwealth. Attorney Lynch.
Good morning. May it please the court. Travis Lynch with the Commonwealth. With respect to the opening, the comment about imagine and so forth, I think the worst that could be said is that had something like an argumentative flavor, like the court commented in the Oliveira case, but I just say wasn't objected to, and overall, the opening was otherwise a general outline of the evidence that was expected to be adduced at the trial.
Well, let's take that first statement. Imagine your car was taken by a best friend, and the first opportunity someone has to talk to their best friend about it, they X, Y, and Z. I was under the impression that it was a real no-no for a prosecutor to, or frankly for any attorney to say, basically put yourself in their place and imagine X. I mean, that strikes me as sort of bedrock law, big mistake. Am I wrong?
Well, I suppose his point is that the defendant was lying about his car being stolen. It was.
So what's wrong with saying the evidence will show that he was lying about his car being stolen, as opposed to saying, imagine, again, we're not supposed to use the term, put yourself in their place, right? When you're talking to juries, that is something that we have said and the SJC has said is error and should not be done. At least that's my understanding. And if I'm incorrect, please don't hesitate to correct me.
Your point's well taken. It could have been better phrased. But again, there's no objection. And his point is that it's implausible that, his point is that the evidence will show, and again, I agree that there's a phrasing issue there. But again, there's no objection, and the jury were told that the opening statement's is not evidence. And the overall thrust of his point is the defendant is lying about his car being stolen because when he speaks with his friend who had the car, he doesn't ask his friend, why did you take my car? I mean, but your point's well taken that it should have been phrased differently, but it wasn't objected to, as I said. And so that does not create a substantial risk of a miscarriage of justice. On the closing, there's a discussion about sympathy. I really don't understand how talking about what Estrada did would evoke sympathy. I think typically when we talk about evoking sympathy unnecessarily, the court is talking about, talking about characteristics of a victim in a victim crime that are relevant to the elements of the crime. That's not what happened here. As to the sympathy point, I believe the prosecutor meant to talk about the defendant's motive to lie. There was a point about vouching because Canini was allowed to testify about various calls that were not introduced in evidence, but he had listened to. There was a limiting instruction to the jury that they weren't to speculate about what the content of the redacted calls were. The judge had ordered that the calls be redacted to exclude irrelevant and prejudicial material. there's no error in having Detective Canini testify. I listened to the call and the defendant never asked that particular question of Estrada.
I wanted to ask you about that because Miss Liddy raised that, and I wonder if there's a hearsay problem here. And I understand this wasn't objected to on that ground, but Canini is essentially testifying about the substance of other people's conversations, including conversations that are not presented to the jury, and saying, well, they never talked about this important issue.
Sure.
Isn't that hearsay?
So,
or am I?
I don't think
conceptualize what the issue is here first.
I don't think it's a hearsay question because Canini's testimony is offered to show the fact that the two people in the conversation did not talk about something, which isn't offered for the truth of the matter asserted, because there is.
It's true. It's offered for the truth of the matter not asserted.
Well, it's offered.
This is the prosecutor's case. Like, he says Estrada took his car, but he never asked, hey, why'd you take my car, man? Right. So that's kind of goes to the heart of the case, right? It's the omission that sort of is really powerful to the government's case here.
Right, but I don't think it's like a verbal act because they didn't talk about whatever that question is. I don't think Canini's testimony was they didn't talk about X. That's not offering any statement for the truth of the matter asserted. It's offering that X wasn't said. That's not hearsay. But it's an interesting idea, but I don't see any authority for having. There's no authority that Canini couldn't testify in this fashion, and it was the calls were heavily redacted to avoid unfairly prejudicing the defendant. That's my recollection of the record. There was a discussion about. There was a citation to Commonwealth against Tanner about how the officers were offering opinion testimony about the defendant's guilt, but I don't think the Tanner case is on point because that's a case that discusses how it's problematic for basically in a drug case for an officer to simultaneously be a percipient witness to activities and then also characterize those activities as a drug transaction. But again, that's not what happened in this case. There were some sustained objections to certain questions, but the judge instructed the jury that the questions aren't evidence. They were told about what objections are for. There was
go ahead.
No, you go ahead. Do you have a question?
I want to ask you one or two issues that Miss Liddy was not able to get to in her argument, but
sure.
So on the issue of the judge's refusal to give a missing witness instruction, my understanding of the defendant's argument is that the Commonwealth should have called Estrada because only the Commonwealth could have given him immunity to testify. What's your response to that?
My response is that there's no authority that says that that Commonwealth is required to give anyone immunity, and that. So that's my response to that aspect of the argument, insofar as it was made. On the point that's raised here, whether Estrada's testimony would have been helpful to the Commonwealth, given that this particular prosecutor prosecuted him personally, and also given the trial evidence that Estrada is friends with Mr. Thomas, the trial judge is not wrong to say the Commonwealth should be. The judge did not abuse her discretion in declining to sanction the Commonwealth for not calling this person as a witness. But to your main point, there is no authority that says that we're required to immunize a witness on pains of getting sanctioned with a missing witness instruction. There's no authority for that.
Okay.
Because really, because whether there's an articulated statutory procedure for seeking immunity, and it's done at the instance of mostly, I mean, I'm in a DA's office, but I think the Attorney General can do so, but it's at the instance of the prosecution in certain enumerated cases. I don't think there's any authority that says that it's appropriate to punish the Commonwealth for not exercising that authority. And it would especially be inappropriate to do so here, given that we're talking about a co-defendant who's friends with the defendant. There was one other point about a legal argument in the required finding stage. Given that this was a jury trial, there's no showing that anything that the attorney said to the judge made a difference to the jury. There's no actual sufficiency argument raised on appeal.
Well, I read the brief as making a sufficiency type argument, but I'm not sure if it's meritorious. But I do want to ask you about the issue about the count of willful interference with a criminal investigation. So the indictment says that the defendant violated that statute on April 9th by misleading Detective Leon Resto. And of course, he didn't speak to Leon Resto until April 19th. He was speaking to Madeira and Lewis on the 9th. So that's in the indictment. And obviously different evidence is presented at trial. My question is is the identity of the victim a required element for a conviction under that statute? And does it make a difference that the indictment seemed to mix up who was misled at particular times?
So first, I would say that everything that those are interesting questions, and I don't think they're really actually argued in the briefing, respectfully. I think there was a mention of it in like the summary of the argument, but it's not actually in the argument. Insofar as, so I guess one way to address that is maybe the issue here is that the date on the indictment is incorrect. And if it's a problem with the date is not an element of the offense. So that would be a variance that would not be prejudicial. As to the identity of as to the specific person named in the indictment, given that the other person that the defendant might have spoken to was also a police officer, I don't think there's any prejudice from that variance.
What did the evidence in your view establish as to who was misled for that violation?
I believe our theory was that the misleading was as to the detective at the later date. But respectfully, I apologize that I'm speaking off the top of my head here because this is not fairly raised on the appeal, respectfully. I think the misleading is, I believe the misleading is when he's speaking with the detective at the bureau later. I think that's what was meant there. But I apologize that I don't have a more specific.
Okay, well, if the evidence were established, let's just assume that the evidence established that he misleaded the officers when he made his stolen vehicle report on April 9th, and those were the officers who were misled
Sure.
at that time. Would that be sufficient to support the conviction in your view?
That would also be sufficient because, I mean, that's also when the statutory false motor vehicle report happened. But inferably, if you lied to them about your car being stolen, you're misleading them. I mean, telling them falsely that your car has been stolen could reasonably or arguably mislead a police investigation about what happened to your car. I suppose also you could take the view that he was attempting to mislead with respect to the investigation of Estrada. I mean, it's 6 of one, a half dozen of the other. But again, it's not really briefed, so that would be my response.
Thank you.
Thank you. Unless there's any additional questions, I'd yield the rest of my time to the court and ask you affirm.
Seeing no further questions, thank you both. Very helpful arguments, and the case is submitted. Thank you.
Thank you.
We will now conclude our sitting on Zoom and proceed in courtroom 3.